Hope is a good thing, and no good thing ever dies. Good afternoon, my name is Vandana Yadav, and today we'll be talking about judicial activism. Judicial activism refers to a judicial approach where the judges interpret the law broadly, and sometimes they go beyond this traditional role of interpreting the law to shape social, economic, or political policies. It is a judicial philosophy where judges use their powers to advance specific values or objectives rather than simply applying the law to the facts of the case. The term judicial activism denotes judiciary's proactive involvement in defending citizens' rights. In India, it means that the Supreme Court and the High Courts have the power to rule those laws that contradict or are incompatible with one or more constitutional provisions that are unconstitutional and invalid. It is to be noted that the inferior courts lack access to this function. They do not have this power of judicial activism. The practice of judicial activism was created and developed in the USA, and historian Arthur stamped the term in 1947. In India, the basis of judicial activism was brought about by Justice P.N. Bhagwati, Justice O. Chinnappa Reddy, Justice V.R. Krishna Iyer, and Justice D.A. Desai. Some of the key reasons why judicial activism is important in India are first, protecting the individual rights, second, is promoting the social justice, third, is ensuring government accountability, and fourth, is strengthening the democracy. Let us look at some examples of judicial activism. In 1979, Hussain Ara Khatun versus State of Bihar case, newspaper reports revealed that under trial prisoners were subjected to inhuman or brutal conditions. In accordance with the right to a speedy trial as a fundamental right under Article 21 of the Constitution, the Supreme Court accepted the matter and directed the state authorities to offer free legal aid to under trial prisoners to assist them in obtaining the justice, bail, or acquittal. Similarly, in 1983, Sheila Barse versus State of Maharashtra case, a journalist wrote a letter to the Supreme Court about the custodial violence which was experienced by the women prisoners in jail. The Supreme Court treated the letter as a writ petition and acknowledged the matter. It then issued proper and appropriate guidelines to the concerned authorities. In 1993, in the case of S.R. Bomai versus Union of India, the Supreme Court upheld the principle of federalism and ruled that the dismissal of state governments by the central government must be for valid reasons and not for political goals. Let us talk about the methods of judicial activism. So, some of the common methods of judicial activism are first, public interest litigation, second is interpretation of the Constitution, third is expanding the scope of the existing laws, and the fourth is judicial review. However, after all this, judicial activism is criticized on the following grounds: violation of the separation of powers, judicial overreach. Sometimes the courts take decisions which are beyond their competence or legal expertise. Third is delayed justice. And the last is lack of accountability. There is no oversight mechanism to actually check the decisions of the judiciary. Who will check the judiciary? Thank you.